international treaties and binding on all persons. As a result, especially the European Convention on Human Rights now operates as a sort of default constitution for the review of legislation. So courts have a constitutional mandate to review acts of parliament, but the combination with the prohibition in Article 120 to review for constitutional review results in a very restrictive interpretation of Article 94. As a result, courts tend to protect civil and political rights while shying away from socioeconomic rights. They also tend to regard the minimum protection offered by the European Court of Human Rights as the standard. One of the Dutch Supreme Courts, the Hoge Raad, explained that the ban on constitutional review calls for the application of the so-called mirror principle, as we can also find in the UK, allowing the courts to offer the same but not a higher level of protection than the European Court of Human Rights. So, as also was explained in the introduction, the functioning of the European Court of Human Rights is very important. As you can see, courts in earlier decades remained extremely deferential towards the legislator, but they became somewhat bolder once the European Court of Human Rights on several occasions condemned the Netherlands for violating the European Convention. Now, additionally, when we look at the EU, courts also have the competence to review statutes against EU law. According to Dutch doctrine, this derives directly from the EU legal order, the priority of EU law, which was recently confirmed by the Dutch Supreme Court. Now, from the beginning, Dutch judges have been very open towards EU law. A recent study confirms that Dutch courts easily refer cases to the Court of Justice of the European Union and do not hesitate to cite its case law in their judgments. In doctrine, the absence of a constitutional court in the Netherlands is regarded as a sort of explanation for this Europe-mindedness of Dutch courts. However, this cannot really be the sole explanation, since in Belgium, for instance, courts give evidence of a similar Europe-mindedness. Now, if we look at we've moved away from the constitutional framework and we look at the political debate, we can see that the question of lifting the ban on constitutional review was raised on several occasions. There were several reports and proposals leading to severe discussions in the late 1960s, the early 90s, and most famously with the Halsema proposal, a private member proposal to partially lift the ban, which was tabled in 2003 in a wake of a government note that was tentatively in favor of constitutional review. So if we look closer to that proposal, the proposal was accepted by a simple majority in the first reading of the constitutional revision procedure, but only by a very narrow majority in the upper house, carried by a single vote. Now, the proposal was welcomed in reports of several advisory bodies, but the Dutch constitutional revision procedure, as we were talking about earlier, requires nevertheless elections, a second reading, and a 2/3 majority in the newly established parliament after the elections. Now, however, this, as you might know from the media, this new parliament was prematurely dissolved without having put the proposal to a vote. Now, the content of the proposal is that it limits the lifting of the constitutional ban to a precise set of fundamental rights. And two elements are striking. Firstly, the lift is limited to rights which are already protected under the Convention, as for which judicial review is already covered on the basis of the treaty clause. And secondly, the proposal opts for a diffuse or deconcentrated model referring to Scandinavian countries, because as stated in the explanatory note, it's also in line with the existing model of review against international treaties, and it's supposed to be the best guarantee against judicial activism. So the question then is, what is the added value? What does the proposal offered in the Netherlands, which they already do not have on the basis of the treaty review? I'll come back to that later, but apparently the political support for the lifting of the ban on constitutional review is limited to the extent to which courts already have the power to review statutes. And the striking thing is that the academia actually agrees. A lot of Dutch scholars absolutely agree with the ban on constitutional review, although some change can be detected. The idea to lift the ban on constitutional review has gained support since the 1970s. Nevertheless, most of the time, advocates of constitutional review set out very precise limitations similar to the ones in the Halsema proposal. Now, much has been written about the issue. I'm not going to go into everything, but I will give you a short overview of the doctrinal debate. Now, Halberstam has written that when multiple institutions compete as authoritative interpreters of the Constitution, then actors will phrase their respective claims of superior legal authority in terms of constitutional principles. These three primary values on which they base their arguments: voice, expertise, and rights. Voice is about which actor has the better claim of representing the relevant political will. Expertise is about which actor has the better claim of knowledge or instrumental capacity. And rights is about which actors provide the best protection of individual rights. And indeed, you can see that in Dutch debate, constitutional review, it comes down to this set of arguments. Firstly, if we look at the voice argument, we can see there that this is a very important argument. It's a strong claim that the legislator represents the political will better than the courts, and therefore that constitutional review should not be allowed. Primacy of parliament is said to be a core principle of the Dutch democratic system. Very few authors refer to the decreasing importance of parliament, especially with the dominance of the executive and European integration. In the Netherlands, the primacy of parliament argument exposes a firm belief in the Dutch democratic tradition, which is at the heart of the debate. Now, some constitutionalists do counter this argument and point out the malfunctions in the representative democratic system. For instance, governments do not necessarily protect minorities' interests. And Halsema, in her proposal, she agrees with this in her explanatory note and refers in particular to minority rights in the current plural society. Now, of course, there's a proportionality system in the Netherlands, which giving some protection to minority tendencies, but still, a recent empirical study on consultation practices in the Netherlands reveals that certain privileged groups have better access to the lawmaking process than other groups. Furthermore, as in any representative system, there are time limits and information costs, electoral pressures, political tactics, etc., that may hinder the legislator. So occasionally, constitutionalists plead for the review against procedural requirements to ensure that the legislator follows the procedure that results in expressing the will of the people. Now, this is nevertheless very rare, as it seems to be in general agreement that courts should not review against procedural norms. What's also very striking is that the debate is usually framed in the context of courts versus the legislator and is not often about citizens. They're reduced to sort of electors, but the Dutch political science literature does give evidence that the citizen does not really confide in the legislator anymore, and he does not consider his vote to be a blank mandate for making right decisions in every individual case. Instead, the constitutional review could give individuals excluded from the lawmaking procedure a forum for constitutional debate. Now, if the court would then uphold the law after proportionality analysis, the law would receive extra legitimacy. Now, this argument is, however, absent in debate because no legal scholar fundamentally doubts the legitimacy of laws in the Netherlands, so there's no real reason to seek this extra legitimacy. There was, however, one author who emphasized that courts, in fact, do not decide in complete isolation, but rather seek social consensus. But no author has really replied to this argument. Now, the counterpart of primacy of Parliament's argument is the assertion that constitutional review would cause judicial tyranny, which would lead to politicians interfering with the appointment of judges, bringing at risk their independency. And it has been claimed in literature that the constitutional ban of Article 120 of the Constitution protects the rule of law because it's a guarantee against political influence in the appointment of judges. Of course, in many systems, politicians interfere in one way or another with the appointment of judges in constitutional courts. This can be criticized, but on the other hand, as long as there are institutional guarantees for the independent functioning of the judges. This may also have the advantage that politicians can bind the court, as you can see, for instance, in the Belgian Constitutional Court. But this is not really what's at stake in the Dutch debate, because, as I told you earlier on, if there's talk of constitutional review, what is meant most of the time is diffuse review and not constitutional courts. Now, this argument shows very clearly that the underlying debate is quite a strict concept of separation of powers. The Dutch constitutional theory does endorse the idea of separation of powers as a system of checks and balances, but opponents of constitutional review rarely apply this to the relationship between Parliament and the courts. But advocates of the review do, to which I'll come back later on. They also give counter-arguments. For instance, courts are limited in their action. They're not allowed to decide by means of a general rule. They can only act after a petition is lodged before the court, and they're bound by that petition. They don't have the power to implement the judgments, so they depend upon the political actors to determine the composition, budget, and the competences of the court. Now, in any case, courts already have the power to review against international law and to review subordinate legislation to the Constitution. Until now, this has not undermined the court's authority, and it has not tempted the Dutch legislator to influence the appointment of judges. All in all, the debate on constitutional review is often misconceived to the question of who has the last word, the court or the legislator, rather than a sort of instrument for institutional dialogue. The court's judgments are discussed by doctrine and by public opinion. They may instigate further parliamentary debate. They may give room for legislative negotiation and compromise, but this insight requires some comparative analysis, which is mostly absent from the Dutch debate. I only found a few commentators point out the joint responsibility of legislator and judiciary to protect and modernize constitutional norms and principles. Now, in international literature, expertise is often used as an argument in favor of judicial review based on the professional and apolitical virtues of the judiciary, but in the Dutch debate, it works in favor of the ban for unconstitutional review. In the Dutch debate, it is often claimed that the Parliament is better placed to balance values and interests because it can do so in general terms. It oversees the different interests at stake as well as the public interest. It is, unlike courts, not confined to the accidental case and the individual interest in play. Also, in Dutch doctrine, it's argued that the legislator himself already reviews bills against the Constitution, so obvious violations are unthinkable. However, there has been some research on the political process, and these studies reveal that the constitutionality test does not appear to be a major concern in the lawmaking process. Of course, as you might know, there's ex ante review by the Council of State, but the Council of State gives an advice which is not binding, so this review differs in significance and approach from one conducted by the courts. The same will probably be true regarding the advisory function of the newly established Committee for Human Rights. Now, in the end, it seems that the MP's focus lies more on political and socio-economical aspects of the bill rather than its constitutional implications. As one could regard judicial review as sort of additional safeguard complementary to the review conducted by the legislator. Now, even if it's considered to be true that politicians will not consciously violate the Constitution, it's not unthinkable that they will. We can draw a similar parallel to treaty review. Earlier on, politicians did not feel threatened at all by the introduction of this treaty review, since it was advocated that Dutch laws are flawless. And this viewpoint, however, fundamentally changed after the European Court of Human Rights found several violations of the Convention in relation to the Netherlands. And in fact, criticism regarding the quality of legislation became a new element in the discussion on constitutional review in the late 1980s. Now, another argument which is rarely raised is that constitutional review does not necessarily deny the fact that Parliament is better placed to weigh interests. Instead, courts could assess whether the lawmaker has made use of its expertise. Now, at this moment, the European Court of Human Rights already carries out such a procedural rationality test. This case law proves that parliaments do not always make the use of their expertise, but however, this procedural rationality test is not part of the current Halsema proposal. An argument that does pop up in the debate is that even when the legislator is better suited, his judgment will always concern estimations of future effects, and a judge will be better placed to assess the effects of a law in a concrete case, with which the lawmaker could not always foresee. In such cases, judicial scrutiny is complementary to the review by the legislator, and this was explicitly brought up by the Supreme Court of the Netherlands. Now, the ban on constitutional review is clearly based on arguments of voice and expertise, on majoritarian claims derived from representative democracy. But other principles do come into play. Since the 1960s, proponents argue that the protection of fundamental rights requires constitutional review. In her proposal, Halsema refers to the importance of developing a consistent system of checks and balances and the rule of law. This opinion is also expressed by advocates of constitutional review in the academic debate. Now, in the Dutch debate, the rights argument is part of a specific discussion centered around the so-called treaty argument. A treaty argument refers to the fact that courts have a constitutional mandate to review acts of parliament against international treaties. And on the one hand, you have Dutch scholars that argue that the review against international treaties renders the introduction of a constitutional review superfluous. On the other hand, the treaty argument is also widely used in favor of constitutional review, since courts have already the power to review acts of parliament against rights inserted in international treaties. It seems to be absurd to deny them the power to review acts of parliament against similar constitutional rights. Now, this argument convinced many Dutch scholars and even politicians to defend constitutional review limited to the protection of fundamental rights. Some scholars criticize this treaty argument for being unsound. They argue that the constitutional review is of a different nature than the review against international law. The Constitution lays down constitutional practice. Unlike the European Convention on Human Rights, it was not drafted with the aim of functioning as a judicial reference norm. Now, this argument expressly doubts as to the capacity of judges to interpret constitutional provisions for the purpose of constitutional adjudication. Now, in reality, from a comparative perspective, it's to be expected that courts will interpret constitutional provisions and reconstruct them for constitutional adjudication, for which they will use international provisions as a reference. This is exactly, for instance, what happened in the Netherlands. Now, as in the Netherlands, the protection of constitutional rights is often conferred to the legislator. Opponents argue that judicial review is therefore of no use. However, in Belgium, the Constitutional Court interprets this as sort of legality principle, protecting democratic guarantees in the case of delegation of legislative powers. Now, therefore, the strongest argument of fact is that the treaty review renders constitutional review redundant. Now, I think this might be true, at least if the Halsema proposal is followed. If review is limited to analogous rights, and if review is diffuse. Nevertheless, even in such a scenario, there is a slight chance that an explicit constitutional mandate might inspire the Dutch courts to move beyond the minimum standard offered by the European Court of Human Rights, since they will not find themselves in the restricted by the constitutional mandate given by Article 94, or they might impose a legality principle that can be read as a non-delegation clause. Also, certain provisions do provide extra protections, such as freedom of education in Article 23 and the ban of censorship. Now, it's clear that the constitutional review has been the subject of long and intense scholarly and political debate. Also, there seems to be a shift towards the acceptance of judicial review, and even though it is limited to diffuse review against classic political and liberal rights. Nevertheless, at the end of the day, constitutional review is still prohibited. The main reason seems to be that there's a lack of a sort of constitutional moment. For instance, the occasion of a regime change, a change in the system of government, or the federalization of the state. Neither does the Dutch political system face persistent political instability. There's no political urgency at all, so then the question raised why politicians would transfer powers to courts and thereby curtail their own powers, especially since constitutional review risks to thwart the constitutional nature of Dutch politics, relying on political negotiations and compromise. That's why even if politicians do support a system of constitutional review, it's very conditional. Constitutional review is not supposed to alter the domestic institutional equilibrium, and thus should not bring about a more intense judicial review as compared to the already existing treaty review. At most, it's expected that judicial review will shelter sort of the domestic system from European dominance. In this sense, the political debate sometimes resembles the Bringing Rights Home debate in the UK. So then the question rises, why do most constitutionalists in the Netherlands agree? Now, I think one of the reasons is that despite the treaty argument, the Dutch debate is situated mainly at a purely domestic context. A Dutch scholar literally argued that the constitutional review debate is a pure national issue that cannot be solved by international tinted arguments. The debate is not founded on fundamental comparative research that could confirm or falsify premises of what consequences of constitutional review would be. Also, the debate rarely takes into account the position of the legislator in courts in a wider sort of European sense. Now, this leads to a sort of puzzling paradox, as I introduced in my introduction, that the Dutch constitutional system is very open towards European law, facilitates a direct effect and primacy of European law, of both EU law and the Convention, which have primacy even over the Constitution. Now, this extreme monist position puts Parliament into a sort of secondary role in multiple occasions. At the same time, the primacy of Parliament is the main reason for opposing constitutional review. But by confiding in and protecting the authority of the Dutch legislator against national courts, the Dutch legal system fails to create a sort of counterweight against European lawmakers and courts. The European Court of Human Rights has emphasized, for instance, in several judgments, that it will respect national interests and values if they are part of an extensive balancing test by the national court, taking into account the relevant convention articles and case law. A constitutional education exercise that is in civil systems rarely the expertise of ordinary courts. The extreme convergence of political and academic debate regarding constitutional review has an important consequence. By opposing constitutional review, politicians try to centralize their power, and Dutch constitutional courts give sort of constitutional legitimacy to this power play. Now, to conclude, in reality, Europeanization has created an important political moment, but perhaps too incremental to be fully aware of. As I said, it has downgraded the national parliament to sometimes to a secondary position, and has caused the European Court of Human Rights to become a substitute constitutional court in the Netherlands, which is quoted not only by Soonse but by many other authors in the Netherlands. However, the current constitutional mandate given to the Dutch courts does not permit them to give much counterweight to the impact of this evolution. As one academic points out, if the ban would be lifted, Dutch courts would be able to offer fundamental rights protection more focused on the specific Dutch situation, with the possibility of going beyond the European standard and perhaps even influencing it. According to the President of the Supreme Court, constitutional review might also improve the acceptance of fundamental rights limits, since they would be limits put forward by the Constitution rather than the fault of Europe, which is now often mentioned by politicians and the media. However, certain politicians seem to prefer a path where the role of the domestic judge is not heightened but rather diminished. The recent Daverden proposal, an MP for currently the biggest party in the Netherlands, the VVD, aims at altering Article 94 of the Constitution to prohibit treaty review by domestic judges.
Well, I have one question for statute laws set aside by Dutch courts because they are inconsistent with European law or international law. I ask this question because, in my opinion, perhaps my colleagues are more informed, we have no statistics about the comparable control de conventionnalité in France. And it's a big question to say if it is important theoretically, and certainly the answer is yes, or is it important also practically? And here, for France, I am not sure that the response is yes. I am not sure that the response is no, but I don't know. And I have read in very general books, English, about the Dutch system. Generally, after the presentation of the Article 94 of the Constitution, there is a sentence like Dutch courts are rather cautious in using this article, which is a great dissatisfaction for me, because cautious does not mean nothing. I would like numbers and cases to say, is it frequent or is it very rare?
Well, I think it's rare, but I haven't found any statistics. There's definitely no official statistics. The only statistics that I know that I've conducted myself was the statistics in how much they actually explicitly refer to the European Convention. And that's actually quite limited. If you compare it to other, I did a study with 3 other courts, and they do it, they refer, because you have the specific situation also of the Supreme Court, it being sort of Cour de Cassation, where it's, you have the Advocate General, which gives a conclusion, which refers a lot more to the Convention and to the Strasbourg case law. And then you have in the case law itself, in the Supreme Court, they refer very rarely. I think in about, depending on the year, between 5 and 8% of their cases they refer to the Convention, and then only in about 1% of the cases they actually refer to Strasbourg case law. But I have no statistics on how many cases they've set aside. But it's the cases that are being raised where things were set aside is very limited. So I'm assuming it's very limited.
We can probably all agree that it's interesting to have the statistics about the preliminary reference to the European Court of Justice and the evolution, which is not linear, but it's another question.
It's another question.
It sounds to Dutch courts that we had Van Gannen laws, and the first great decision of the Luxembourg Court, and it's enough for the Netherlands, perhaps.